cause the defence to have the entire burden of proving innocence. Of particular concern on this issue is the delay in the proceedings we have here. This will impose restrictions on the ability of the defence to prove innocence arising from facts which were in existence nearly 40 years ago. These charges will be brought by an accuser, and it's that party that has to prove the case beyond reasonable doubt. Let us now look at inadequate evidence safeguards. The removal of the Criminal Procedure Code of 1898 and the Evidence Act of 1872 from the proceedings under the International Criminal Trials Act of 1973 emphasizes the capacity for unfairness in these trials. Section 19 creates a non-technical procedure and permits a wide variety of different sources of evidence that will be admissible in this international crimes tribunal, which would not be entertained or permitted in your national criminal trials. Normal rules for judicial notice found under your Section 57 of the Evidence Act have been altered in Section 19, subsection 3. But significantly, under Section 19.4, it says this: a tribunal shall take judicial notice of official governmental documents and reports of the United Nations and its subsidiary agencies or other international bodies, including non-governmental organizations. This permits the judges to take judicial notice of the evidence from a privileged few sources: government, United Nations, and other international bodies, not from other sources. Is this fair? This equates the documents from such agencies with the facts of common knowledge that give rise for judicial notice. Therefore, government documents and reports are given the status of evidence automatically and without capacity for challenge, and scrutiny of the authors, and scrutiny of the content, and challenge of the sources. This becomes a powerful tool in the hands of the government, which may well be intentioned to present its own picture of events at the expense of the truth. Further objection to the provisions of the International Criminal Trials Act 2009. In 1993, by Presidential Order Number 16, the liberating forces were given immunity from prosecution under the International Crimes Act. The objects of the prosecutions were thereby defined as being only those from the forces of Pakistan. The amendments to the Act in 2009 did not incorporate the presidential decree so as to show with transparency to all the world the full terms of this statute. This is a clear attempt to hoodwink the international community into believing these are impartial laws. In fact, there can be no clearer indication of the intention to apply these legal procedures in a discriminatory way and in defiance of the constitutional duties to equality and human rights. In terms of the International Covenant to Civilian and Political Rights, Article 26, have clearly been overridden. Let me now conclude, and I thank you for listening. The amendments to the Constitution that have attempted to prevent challenges to the International Criminal Tribunal Act are not sacrosanct. The Supreme Court of Bangladesh has previously ruled amendments to the Constitution which were fundamentally inconsistent with the totality of its provisions were unlawful. This ruling affirmed the inherent right of the judiciary to judicially review the legislative acts of Parliament, as is found in the Constitution at Article 102. The Constitution is also to be reprinted, I read today in the Daily Star, in the light of the recent Fifth Amendment decision by the Supreme Court. The serious crimes committed in the war no doubt created pressure to reduce the fundamental rights of those detained or suspected of being responsible. However, the substantial delay in bringing any prosecutions has undermined any argument of expediency in the national interest. That delay should in fact now cause the enhancement of trial safeguards to ensure that justice is in fact done. However, the cost to society arising from convictions obtained through a lesser standard of justice can only mean the diminution of the historical record as it stands for future generations. The retention of the death penalty under Section 20, sub